Good morning. I'm Betsy Urbance, Illinois Realtors General Counsel, and we are welcoming you in today to our Winter Meetings 2021 Legal Update. Here we are in our radio studio, and we sure would prefer to be with you in person, but this will have to do given the circumstances that have been 2020 and seem to be bleeding into 2021. On the bright side, and on the heels of the last few days, where lights have been shining on remarkable women and loving that turtlenecks are back in, I'm honored to turn the program over to our own remarkable legal hotline attorney, Anneliese Fierstos. She'll bring us up to date on the hot topics, the hot legal topics that come in through the hotline, and we will also answer some questions that came in prior to this session. And then finally, I will follow up with other topics that we continue to monitor in the industry of legal import to our membership. So with that, I'm going to turn the program over to Anneliese and have her go.
Thank you so much. It's nice to be here today. I also wish we were in person like we were a year ago. That seems like a long time ago right now. But by way of introduction to the top 5 for legal, something that I think the two of us sitting at this table both really agree, there's something very exciting. The rules that we've been waiting for and that we've been referring to as proposed rules are coming into effect and should hopefully be signed by the end of February. Right now, in mid-February, there was a second notice for the rules filed on January 15th, 2021. And there is a meeting set for February 16th, 2021, and the information in those rules hopefully will become official, and I relied on those quite a bit in preparing the top 5 because they will make a significant impact on how everybody in our state is doing business. Really, one of the top 5 heavily influenced by these rules, questions and topics that I have been addressing on the hotline is the concept of the virtual office. I think that everybody probably remembers from our other updates that when the new Real Estate License Act came into effect, they introduced the concept of virtual offices, but we didn't have a lot of other information. And so your calls to the hotline were probably a little frustrating on the topic because generally I was able to say that virtual offices were contemplated and they're now legal, but we just had to say we just don't know what it's going to look like in practice. Well, now we have a lot more information. If you look at when the new rules are officially published, if you look at the rules under 1450.610 subparagraph D, there is a very clear outline with respect to what needs to happen in order to set up a virtual office. In order to set up a virtual office in Illinois, a sponsoring broker needs to be able to demonstrate that the licensees that are assigned to that office are engaged in licensed activities, they are offering real estate services, they are holding out to the public that they are engaged in licensed activities, they are maintaining electronic files securely, including their escrow records, all in the same format that they were generated, sent, or received. They are able to make secure electronic files accessible to the department for inspection. Maintaining files of all required records need to be kept for a minimum of 5 years, and they need to back up the electronic files monthly. And I think Betsy could attest to the fact that I say all of these words, but I only know what a portion of those words actually mean when it comes to managing data. That's a specialty, and so I would encourage anybody who's planning on setting up a virtual office to consult with a data specialist. This is not something that you want to venture out in on your own if you're not comfortable in that world, because if for some reason you lost all of your data, that could be a significant problem for you. So wouldn't you agree? I would say
absolutely.
Definitely consult with a specialist, because it's a new concept and it's new to Illinois. In the real estate world, and so it's not something to be taken lightly or haphazardly.
And how would, just share with us and share with our audience what we mean by a virtual office. Where's our business happening?
Well, a virtual office is no dedicated space or fixed physical location. So essentially, you know, I do get a lot of calls and somebody will say, can I work out of my home and maintain a virtual office? Well, the virtual office isn't in the home at that point. It's in the cloud, so to speak, if that's the way you want to define it. So your records are all virtual. They're in a cloud. Documents are all in a cloud. You don't have a defined office space with the department. And I'll go on to discuss a little bit about what you need to do with respect to complying with the department so that they actually know what you're doing and where you're doing it. The rules go on to state that the virtual office has to have a digital infrastructure that will facilitate the transaction of businesses, communications, advertising, and real estate services through a virtual office website, a URL, or other digital platform inviting the general public to transact business. And digital infrastructure is kind of an intimidating word, but it mainly means you have to have those foundational services that are necessary to support information technology.
Right, and we're probably talking to the kids, and the kids are like, dude, I know what a digital platform is and a website. So really, it's essentially operating your office through a website.
Yes.
So
yes.
The website has to act like your bricks and mortar
yes.
office.
So you'll have to have a computer. You have to have a computer.
Sure.
But this platform, this website, URL, or digital platform shall, in order to comply with the rules, be registered with the division. It has to display a current registry of all sponsored licensees and their license numbers. It has to display your city and geographic location and the state where your services are offered. You have to be able to display contact information for the designated managing broker. So a virtual office has to have a designated managing broker just like a physical office does.
All the provisions of the license law and the rules will apply
yes.
to the virtual office. So you have to be able to do through virtual means the same things that you would do in your physical bricks and mortar walk through the door office.
Exactly.
Right.
And the designated managing broker information has to include name, phone number, and an email address. If a sponsoring broker has more than one designated managing broker, the contact information for each of the designated managing brokers needs to be included, and the names and license numbers of the licensees that they supervise. They need to maintain a secure intranet or secure portal that's accessible by all of the employees. They're independent contractors, so your licensees, and you need to be able to, if the division wants to access your web-based platform, you need to be able to provide secure access to the department or the division upon their request. Finally, virtual offices must comply with all advertising requirements under both the Real Estate License Act and under the new rules. And the next topic that I'm going to discuss is advertising. So they go hand in hand. Your virtual office will need to comply with all of the things that I'm about to discuss in this second section. And just as a side note, you know, when we throw all of these information with these new rules out there, you know, you can look up the rules and you can read the rules. And so, you know, pull out a pen and paper and write down some of these sections and make a little note because it's going to be available. They're well drafted. Thank you, Betsy. And to the department.
Working diligently with the department.
With the department. They're well drafted. It's clear. We don't expect you to remember this off the top of your head. You know, pull out a pen and paper and write down the sections as I cite them, particularly with these advertising concepts. I'm getting 2 frequent advertising issues, and we anticipated these, didn't we?
Yeah, we did. Advertising questions are always the most common questions. They're the favorite in our industry as far as topic for complaint because competitors like to complain about advertising, and it's easy because you see it on a billboard or a website. So these are really, really hot topics. And honestly, before you get going, I'm not going to say that they wouldn't be enforced, but I would say that the department has to prioritize what they go after.
With respect to advertising and the concept of advertising, it is complex. And so when we address this issue today, it coincides with questions from a member and a question that was submitted going into the podcast today. And that question was, what type of topic should I be addressing in my education classes? And these two concepts should very clearly be addressed. These are two important things that are somewhat complex, but if everybody is educated on those, it will make everybody more comfortable with advertising. The first frequent question I am getting is with respect to the change to Section 1030 of the Real Estate License Act addressing teams. That section was redrafted to prohibit the use of inherently misleading terms as part of team names, like the following terms: company, realty, real estate, agency, associates, brokers, properties, or property. The new proposed rules have allowed some have provided some clarification, and the rule itself is, if you have your pen and paper out, it's 1450.715 subparagraph A2, and it provides clarification by stating that the use of inherently misleading terms are prohibited, and this is the important language, unless the term is followed by the word team. So an example would be, if I was a licensee and a designated managing broker, I had my own, or even not, but I had my own team, and I wanted to name my team Anneliese Fierstos Real Estate. Well, I can't do that because real estate is a prohibited term. It's prohibited because it makes it appear as if I'm a stand-alone licensed entity, and I'm not, I'm a team. So I can cure my defect in my name by saying Anneliese Fierstos Real Estate Team. So that's pretty simple. I've gotten some calls over the last week with some interesting additions to the word team at the end of the name. And you know, it will work, but I think you also need to work with what the public is going to understand. You don't want to create some name that's actually goes the other way and is a little bit misleading on some other faction. So you know, you want to keep it simple. But the use of the word team, if you're using one of the common words, realty, company, real estate, agency, that will cure your defect. The second concept that needs to be included and remembered is that all advertising must include the licensee's name, the sponsoring broker's name, and meet size requirements that are addressed by the Real Estate License Act 10-30. This is where we're getting a lot of questions.
Right.
And this isn't as simple of a concept. And so the proposed rules have clarified the size requirements. And the section that you want to review and maybe read 3 to 4 times is 1450.715 subparagraph B1. So I'm going to say it again, 1450.715 subparagraph B1 of the new rules.
Right. The other thing you can do is Google Illinois Real Estate License Act Administrative Rules, and then those will come up almost right away. Click on that, and then you go down to the section that Anneliese just gave you.
Yes.
And it's just a little history here. There used to be a comparison size requirement between licensees and their sponsoring brokerage company. That was a way long time ago. Then that went away. Then it became abused, and you saw a lot of misleading advertising where individuals and teams were making it appear that they were the show, and you know, putting a microscopic reference to their sponsoring company in the very, very bottom, like the car ads, right? So in this iteration of the License Act and the new rules, they put the size requirement and the restrictions back in there. So Anneliese is going to tell you how the safe harbor tests that are now available in the proposed rules that we hope become effective sometime mid-February.
And as I go through this, keep in mind, as I read this language, visually speaking, you're trying to create an advertisement that makes it clear that as the licensee, you are not the licensed entity. That's the purpose of this language and these provisions, so that you are not misleading the public in suggesting that you are the important licensed entity.
You're important,
but you're not the licensed.
You're working for a sponsoring company.
You're working for a
that needs to
sponsoring
be
company.
identified.
So the first safe harbor provision is the font size used for the letters in the sponsoring broker's name are as large or larger than the letters used in the team name or individual licensee name. So you're looking at the font size and you're comparing the font size between the sponsoring broker's name and that of the team name or the individual. The second test, if you pass this test and then you're meeting the requirements, the area in terms of the height and width containing the sponsoring broker's name is as large or larger than the area in terms of the height and the width of that of the team name or the individual licensee name that's also in the advertisement. And the third test that would help you pass, the other safe harbor provision, is any logo, emblem, label, trademarked image, or similar identification incorporating the sponsoring broker's name is as large or larger than that of the team name or the individual licensee's name. Now, we've prepared some visual examples, and the visual examples will assist you in understanding this. So those have been mocked up. You know, they're not real, but I think if you take a look at those and if you look at the example that is incorrect, you will see the difference and it will help you understand these provisions.
On the logo thing, let's clarify a little bit too, because what the new proposed rules say is that the logo or the trademark is not part of or cannot be used in lieu of the sponsoring broker's company name.
Yes.
Unless it actually does, if that makes any kind of sense. You could have a logo that just has your franchise identified on the logo. That's not your company name. Your company name is going to be your franchise plus whatever your company name is. And we have seen examples where the sponsoring company actually puts their entire team name, incorporates it into the logo, which our graphic I think will show you. Mm-hmm. And if that is the case, then that is that third safe harbor situation where that's got to be bigger than the licensee's name.
Yes.
If that makes sense.
Yes.
Yeah.
Our third topic, or hot topic on the hotline over the last year, has been related to property management. And one of my most frequent questions is, as a licensee, can I engage in property management on the side of a real estate practice for a landlord or a property owner? And it seems like there are a lot of licensees out there that are getting approached by landlords and property owners to manage property on the side, probably because you're so good at the business that you're doing.
And let's be clear that on property management, we're not talking about just shoveling the driveways and mowing the lawn. We're talking about being the third party in charge of the rental activities.
Yes.
Because that's covered by your real estate license just the same way that your sales brokerage is covered.
Yes.
Right.
Now, if you're the 100% owner or you own the property with the spouse, that's different. And then you can engage in managing the property that you own 100% with either by yourself or with your spouse. But if that's not the case, then there are certain things that the License Act, under the License Act, that are going to stop you from engaging in property management for another entity. You have to keep in mind, when you are a licensee, you wear that hat, and you can only wear that hat for the sponsoring broker that holds your license. So that means you can only do real estate activity through your own sponsoring broker, and under the Act, it's very clear you can only have one sponsoring broker at a time. And licensed activity, Betsy touched on this already, is the activity included under the definition of broker that's under Section 1-10 of the Real Estate License Act. The definition of broker under the Real Estate License Act has 12 subparagraphs addressing licensed activity. It includes collecting rent, negotiating real estate transactions, showing the property, and that's not an all-inclusive list. No, it doesn't include probably shoveling snow, but that list is very long, and the area can get very quickly gray, and a licensee could very quickly step into the wrong shoes,
Right.
you know, and put themselves into a situation where they're placing their license at risk because they are doing licensed activity for somebody that is not their sponsoring broker. Second, keep in mind, as a licensee, you can only be compensated for real estate activity through your own sponsoring broker. So you couldn't be paid by the owner of a property management company without some business arrangement being made between the sponsoring broker, and that would be sponsoring broker to sponsoring broker, not between the licensee and the company. So you cannot be paid directly for any real estate activities. Anything that you do in that 12-paragraph list, any compensation you receive for those activities has to come through the sponsoring broker. Another frequent question that I'm getting, to follow up, another issue that I get on the same topic is, can a licensee open up their own property management company and run that on the side and then can still continue to work for their current sponsoring broker? Well, no, because if they open up another company to do property management, it likely needs to be a licensed entity because it's engaging in real estate activities. And they can't do work for that company, even though they might own that company and their sponsoring broker. If somebody wants to do that, what they need to do is either leave their current sponsoring broker and go over to that licensed entity and become the designated managing broker of that entity.
If they have a managing broker
If they have the managing broker license, and then they run that company. Or if they want to open up a company that does property management, they might need to hire a designated managing broker. When they get the entity license, they'd identify that person as their designated managing broker, and that individual would run the company, and the licensee would only benefit from that relationship financially as an owner. They would not be engaged in any of the real estate activity for that second company.
If they stay and work at their prior
If they stay and work at the prior brokerage,
Mm-hmm.
yes. So, and finally, and I think everybody's probably almost relieved I haven't said this yet, COVID. It's funny because, I would say March, April, every call was about COVID. It was all COVID related. We still have all of that information on our webpage. If you are dealing with tenant issues and COVID issues, we are updating constantly. As soon as things change, we try to stay on top of getting that information out there. But really, over the last several months, I'm not getting a lot of COVID issues, COVID itself, as far as dealing with the pandemic. But I am getting some fallout questions, and mainly it's related to the eviction moratorium. And we do have a little bit of an update in Illinois. The moratorium is currently extended until February 6, 2021, but keep an eye on our webpage because that date has been moving constantly, and depending on what happens over the next few weeks with the changes in our numbers in the state of Illinois and hospitalizations, that could be extended yet again.
I think we fully expect that it will be extended. I mean, stay tuned, but over the course of the lame duck session with negotiations on relief legislation, et cetera, I think the real feeling, it's not gospel, but the real feeling is that it will be extended at least through March.
Yes, and keep in mind, the language has been clarified since the first moratorium. So when you read the newest executive order, it's clear that there's nothing about this moratorium to indicate that tenants should not have to pay rent. They are not relieved of their obligation to pay rent under these moratoriums. And they've added some additional language that helps the landlords in some sense. The moratorium does not extend to all tenants. It won't extend to circumstances where the tenant might pose a direct threat to the health or safety of other tenants. It would not extend to somebody who presents immediate or severe risk to the property. And it would not extend to anybody who violates an applicable building code, a health ordinance, or a similar regulation. Now, we'll call those safety provisions for the landlord, should not be interpreted by the landlord themselves. If you feel that you have a tenant who falls into that criteria, and so you should be able to initiate eviction proceedings, you need to turn to an attorney for some assistance, because the language is there, but it hasn't been interpreted, and that's not something that the landlord or somebody should interpret without the assistance of legal counsel.
The landlord or the property manager.
Property manager, yes.
A lot of our folks are both.
Yes.
They're a landlord or they're a third-party property manager. We're trying to lump them together as housing providers.
Yes.
So.
And with respect to the federal stance on the moratorium, the CDC came out with a statement on January 20th, 2021, that they are extending their federal moratorium until March 31st of 2021. As an Illinois property manager or landlord, you will follow the Illinois law until that runs out, and then you would check the status of federal law on the evictions. So currently, you would start with Illinois law, and then you look to federal. If the moratoriums in Illinois are lifted, you check again with the feds.
And one more thing is if you're in Chicago or some other place where they have a local moratorium in effect, I think Chicago's right now says that it would go 60 days beyond the expiration of the state moratorium. So in that event, you'd follow Chicago's state. Let's say, for instance, state moratorium runs out and federal's still out there, but you would follow Chicago for 60 days after.
So it goes city, state, federal.
Yeah.
Small,
Something
big,
like that.
bigger.
Yeah. If it's stricter and as long as it doesn't conflict, and it's all something we're not going to get into today.
Right. And then my final issue, we received a few questions from members, and one was about whether or not the use of greatschools.org or the practice that they use in ranking schools is something that's misleading to the public. I can't offer an opinion on greatschools.org specifically. I think that everybody needs to keep in mind that realtors generally try to avoid discussions about schools because it can raise issues related to steering if there appears to be some correlation between the quality of the schools and the composition of a neighborhood. And so realtors are often advised to refer their clients to third-party information. Great Schools is one of the third-party databases that you can go to look up that information. If you look, the question was specifically about greatschools.org. If you go onto their webpage, they have what I would call a disclaimer. They have a summary page that talks about their resources for the rankings of the schools, and they make it clear that the data that they are providing is only as good as the data that's provided from the schools. So not all schools will provide all test scores, or they might provide everything,
And sometimes it's not about test scores. You know, people rely on test scores, and what does that really mean?
Right, and they talk about test scores, but they talk about composition, they talk about attendance, they talk about college acceptance, but each school keeps their records a little bit differently. And if you think about it this past year, I would say it's all going to be skewed because almost everybody's gone to remote learning. So you can't even.
Who goes to school anymore? Right.
So the data that they're using now, you know, might not be so good. That doesn't mean Great Schools is not a great third-party, you know, resource. It's just that give the third-party resources to your consumers. And one of the best things to do, Betsy, we were talking about it before the podcast, National Association of Realtors, and I think you're going to address this a little bit about schools. They're recommending go directly to the school and take a tour of the school and talk to parents, talk to the school board, attend a school board meeting. That's a good way to tell your good information to give your clients if they're trying to evaluate a school district. So I think that wraps up the on the hotline. I probably went way over my
Super
time.
hot on the hotline.
And I'm
going to
gonna
go over your time.
I'm going to turn
We've got all kinds of time here. Just to dovetail on the Great Schools question, you know, we won't say whether or not it's misleading. That's a factual question. Everybody knows I love to say it depends on the facts. And hopefully y'all caught last week our Business Issues Forum, where as part of our forum we did show a little video clip from the National Association, because schools is a really big The issue of schools is a really big question, and people like to be able to provide that information. But as Anneliese said, you don't want to use it as a subterfuge for providing demographic information. Oh yeah, I'll give school information, and they'll then have all the demographic information for the particular area. You don't want to use it in that way, and you don't want to insert your personal opinion as to what's a good school and what isn't a good school, because what might be a good school to you isn't necessarily a good school to someone else, because you don't really know what they're looking for. So you do want to, and this little video clip is, so hopefully you caught that in Business Issues, where they do send you to the school district office, send you to, go talk to a family that's in the school district and find out about the schools. So objective sources of information is the way to play that question. We did get another question in before I launch into some of the really hot issues that we continue to monitor and that are changing kind of as we sit here today. We got one that this question comes up again and again, and it's about these apps for your phone, one of which is called Forewarn, but it's an app that's used to screen folks that are looking for rental properties or to purchase properties. And it seems like the hottest thing since sliced bread on the issue of safety for real estate brokers, because I've got the app on my phone, I can click this person's information, and this big warning sign comes up. However, you have to be very careful that you don't use it in a discriminatory manner. And so here's the deal. If you want to use it, or if your office has this product or an app like it, and you use it to inform yourself about your safety, so let's say something comes up where this person has a murder conviction from 15 years ago, you cannot deny that person. If you're in Chicago, you can't deny that person based on that fact, but it should inform you that, you know what, I'm going to take a safety precaution. I'm going to go with a buddy, which you should probably do anyway. I know it's easy for us to sit here and say always take a buddy, or meet at the office or what have you, but those apps should be used to inform you on safety questions, but not to determine whether or not you would provide service. Now, having said that, we had a fact situation that came in, I think through the hotline or through one of our presentations, where they said there was a person who was clearly calling up real estate agents in the area and wished to do harm to the real estate agent as opposed to really look at properties.
Right.
So they were really looking for the appropriate crime scene, allegedly. Everybody's allegedly until they're convicted. But if I'm the managing broker in that situation, and I know of that situation, I'm going to err on the side of not serving that client
Right.
over, being worried about some charge of inadequate treatment. But just be aware that we've got information out there on our website on this particular app or this type of app, and how you could use it. Be careful you don't use it in a discriminatory manner. In Illinois, you cannot deny service to someone based on an arrest record, a juvenile record, or a record that's been sealed. So and to do so would violate fair housing principles in the state of Illinois. In Chicago, you cannot deny service to someone who's got a conviction in their record that's over 3 years old. So, and that I'm generalizing, there are some specific situations that apply there, but just be aware of that you need to always treat folks consistently, use the same procedures all the time. Scripts helps, procedures, policies, so that you can show that you're treating those folks that are seeking out real estate services equally, and show them all the stuff that meets their criteria. So those were all the questions that came in prior to this session. And now we're going to kind of turn the tables a little bit. I'm going to bring you up to speed on what's going on. During the lame duck session, our legislative advocacy team, our governmental affairs team, together with the legislative attorney and our exec team, worked so hard during the lame duck session to present a housing package of legislation. We put the package forward through the appropriate legislator to try to get a procedure in place for when these federal assistance funds come in based on the relief, the COVID relief package that was the old one, where there's money still available, as I understand it, then the most recent one on 12/21, and now the new president has another relief package at the federal level. So there's this money that's supposed to be coming in for rental assistance. And we had a package, and one of the landmark provisions in that package is how to administer those monies through a state agency to get it out to the housing providers who need it and the tenants who need the relief. And unfortunately, that didn't pass, but doesn't, I was going to use two negatives again. We're going to really be pushing that in the next legislative session. And that Anneliese will correct me if I'm wrong here. I want to share with you the latest that we know on vaccines and the availability, the distribution, and then a little bit about maybe office policy and procedure and what y'all wanted, what we're going to do in our office and what we think we're going to do and what you might want to do if you're a managing broker in an office. But first, with regard to availability and distribution, no doubt if you're tuned into the news, you've seen that Illinois has several phases. They have 3-phase subcategories of phase 1 and then phase 2. Phase 2 is the catch-all. Phase 1A started with the priority vaccines being distributed to healthcare workers at healthcare facilities and long-term healthcare facilities.
Yes.
Are like the probably old folks homes and
Yes.
stuff. The
Only
more
the
senior
assisted,
generation,
right.
yeah, assisted ones.
Not just a living facility. It had
Right.
to be
A healthcare.
a healthcare facility.
Okay, so now, I don't know, you really need to check by county where you are. In Sangamon County here in central Illinois, we are in phase 1B presently, and that's moving into essential frontline workers, which I'll probably miss some of them, but it's the first responders, the educators, the food and the agriculture, corrections officers and inmates, and also those folks that are over 65 years old. There's a story about 75 originally, but suffice to say in Illinois, it's 65 and up.
Right. The national CDC was 75, and
Yeah.
then Illinois reduced that age to 65. Several states did
Yeah.
because they felt like it was going to protect the public more if they could encompass
Right.
more people,
More people.
Of that age.
So if you're out there and you're a real estate broker and you're 65 or over, check your county and try to make your appointment for your vaccine. We called our parents immediately upon finding out that 1B is moving in Sangamon County, so that's good. As far as the age, the low-end age, I've seen 16, I've seen 18. I think most of the stuff says 18. Anyway, for the low end, doesn't apply presently unless we have an 18-year-old frontline worker. I suppose it does apply in that situation. 1C, this is where real estate brokers will be according to the definition in the bulleted list. Real estate is an essential category of workers. So these are the other essential workers, and I had a list of them here.
I think it included
Where are they?
finance.
Yeah, 1C,
Housing.
here we go. Yes. Industries like transportation, logistics, water, wastewater. I'm taking this from an awesome article that Anneliese wrote that's probably on our website right now. Food service, shelter, housing, finance, information and technology, public safety within the public health workers. So that would be where the real estate brokers fall, as far as I read that. And then finally, the phase 2, which is just everybody else. 16 and over if you're getting one of the shots, and 18 and over if you're getting the other shot, and I'll find that somewhere in my notes. Now, with regard to vaccines still, but what are you going to do in your office? Are you going to have a policy of requiring the vaccine? Are you going to highly suggest the vaccine? And we've been kicking it around here in our office, and everything that our research indicates is, number one, we're in this period where these vaccines are under emergency use authority, so there's not permanent approval of the FDA at this point. But I'll tell you, I'm going to be in line as soon as I can get in line, just saying. But where we're probably headed as far as Illinois Realtors policy is to highly encourage vaccination. You can require it. There are certain reasonable accommodations or exceptions typically in other shots where if you have a medical disability, you have a severe allergy to one of the ingredients of the shot, obviously you can't get it then.
Or if you recently had COVID, I think that
Right,
might be.
yeah, that could be. And also religious. If you have a firmly held religious belief, then against vaccines, that would, you wouldn't have to get the vaccine if it were required of you. Note that personal and political beliefs are not religious, and they're not really protected.
Mm-hmm.
I mean, sometimes they coincide, but as a class in and of themselves, I just don't want it. If it's required, I just don't want it. Won't probably work.
Well, and if I was creating an office policy, I would consult with my legal counsel as I created that policy, because as other vaccines become available in the future for other unforeseen situations, you might have a policy. You need to consider what's going to happen down the road.
Right.
This may not be our first situation like this, so.
Lord help us all. Hopefully, not in our lifetimes. We're
Right.
not talking about
I
that
hope you're right.
COVID-3 vaccine.
Right.
There it is. I think the other COVID-related subject that I was going to visit about, we've covered it pretty well. I'll just kind of gloss over it, but be aware that there was another recent federal assistance bill that came out on 12/21/2020. It was a huge bill, and it was attached to the federal spending bill. So that made it a little bit different. But here's some highlights for those in our industry that, you might be interested in. Stimulus checks, $600 depends on income levels, but $600 to individuals, $1,200 to married under certain income level. Money to states for rental assistance to states and local municipalities. I think, depending on the size of the city would get its own share of the federal assistance for tenants and housing providers. I think Illinois' share was between 150 and 950 million out of the however many billion was in this last package. The federal eviction moratorium at that time was extended through January. As Anneliese shared with you, on January 20th, it was extended by the CDC. The new director, Rochelle Walensky, extended the moratorium to March 31st federal. Doesn't really apply here to us unless and until the state one ends. It continues the PPP, the Paycheck Protection Program, through the Small Business Association. The Economic Injury Disaster Loans were extended. And the other thing, especially for some of our local association executives that might be listening to this session, 501c6. If you are below certain levels in your lobbying activities, you might be you might qualify for a PPP loan depending on your circumstances. You can't have more than 300 employees, and you can't have more than 15% of your receipts or your total activities be through lobbying. But we're trade associations, so there is lobbying, so you got to talk to your people and find out if you meet that. Take a breath. And then we're studying the new Biden proposal, which is not in effect yet. It's purely that. It's a proposal. It's been called the American Rescue Plan, and the plan says that the eviction, foreclosure evictions, and the forbearance provisions may actually extend through September of 2021. There is a plan to provide more, to provide legal assistance funds for those folks that are caught in that eviction, foreclosure, forbearance situation. There's a plan for more rental assistance for housing providers and tenants. And so hopefully we'll get some legislation in Illinois that will inform our ability to distribute those
Right.
funds to the people that need it the
Provide
most.
people get some
Right.
guidance.
Right. And there's the hope is to have about 25 billion in there for housing and 5 billion for utility assistance, and then another 5 billion to assist and prevent homelessness. So those are some of the dot points that are in the Biden proposal. We will be monitoring that as it becomes reality or doesn't become reality. We will be informing the membership. So that's all I want to talk about with regard to COVID. Okay. So, bringing us up to speed, 2020 has been a most transformative year, full of upheaval, full of just sheer craziness, and fortunate. The good that's come out of it is an increased focus on diversity, inclusion, and equity, not only in our industry, but in our country, in our towns, in our homes, just everywhere. And along those lines, the National Association and the states and the locals are following through with the focus on diversity, inclusion, and equity in everything we do. NAR has implemented a program that goes by the acronym ACT, Accountability, Culture Change, and Training. And with regard to that, I just kind of want to do a bit of a commercial on a program that National Association has made available, and I'm just amazed that a lot of us haven't heard about it yet, and I intend to do it myself. But it's a simulation training that you do in the privacy of your own office or at your own laptop, and it's called Fairhaven. And what Fairhaven does is put your little avatar in a situation where questions start to happen and situations start to arise where if you don't act or answer in an appropriate manner, you can find yourselves in a situation where you're even unintentionally discriminating against someone who's in a protected class. So I would encourage everybody to check out Fairhaven. I think it's getting really good reviews, and I'm really actually looking forward to trying it out myself and hoping that I do pretty well.
I know I'm hoping I do well.
Yeah, but
surprised.
the thing is, yeah, we all have our own histories and stories, and hopefully this will help us open our eyes. And it's just so important, I can't stress enough, in your life and your practice, wherever you are, to be consistent.
Well, the quote you have on your bulletin board, that you hung on your bulletin board.
Oh yeah, that was.
If you're not intentionally being inclusive, you're being exclusive.
If you're not,
right?
if you're not being intentionally inclusive, you are being unintentionally exclusive. And that's our friend Nate Johnson.
Yes.
That's a quote from our friend Nate Johnson out of St. Louis, who was a panel member for us in our last business issues presentation. And I thought that was excellent, and I wrote it down and I pinned it.
It sums it up
to
in such short amount of words.
My corkboard. So I look at that every day, and now that I'm in here with all my notes, I totally lose my mind.
I threw you off, though.
No, not at all, not at all. So anyway, take a look at Fairhaven, and then the other big, really small but big change to the NAR Code of Ethics recently was the addition of a new standard of practice under Article 10 of the Code of Ethics, Standard of Practice 10-5. And what Standard of Practice 10-5 does is makes it a violation of the Code of Ethics, of Article 10 of the Code of Ethics, if you are, and I want to find, if you are found to have, well, the standard of practice says this, I just want to read it to you. Realtors must not use harassing speech, hate speech, epithets, or slurs based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Those are the protected classes under the Realtor Code of Ethics. The federal law has the 7 protected classes. Illinois state law has a long list of protected classes. Local municipalities and villages sometimes have another list of protected classes, and the Code of Ethics has this list of protected classes that I just read to you. So not only did this standard of practice, after you can go to the National Association website and read about the request to do this in the wake of this summer's events by a local realtor or a state realtor association, that the Pro Standards Committee look into this, and the just extreme vetting that went into this idea, that came up with all of the guidelines. There's new guidelines, the Code of Ethics and Arbitration Manual, which is basically the procedural book that pro standards committees follow in a pro standards or an ethics complaint. Hopefully everyone's aware of that book, but the 2021 version is out there. There's new guidance in the form of, it's the appendices that inform the articles and tell the pro standards committees, kind of give them guidance as to how to reason through these types of situations. There's new guidance there. It's Appendix 12 to Part 4, I think. On the hotline, it's procuring cause. It's always Appendix 10 to Part, or there's an appendix that we always refer to. But back to this situation. So what the National Association is doing right now is training on this new provision. And before I get too far afield, also policy statement number 29 was added, and used to be that the Code of Ethics only applied to your activities in the context of your real estate brokerage practice. So policy statement 29 makes the Code of Ethics applicable to whatever you do, but before you get your hair on fire, consider that the other articles, there are 17 articles in the Realtor Code of Ethics, all but probably 10 specifically deal with your real estate brokerage practice.
Yes. Well, and
so,
this is just to tag on, I get a lot of calls, ethics calls, whether
right.
or not this is an ethics citation. And I think that it's important to keep in mind that if you are a realtor, so you're a step above a licensee, you're paying your dues, you're a member of an organization that has made a choice to do some self-policing, for lack of a better word, and so there's a sense of pride. The Code of Ethics is something that not everybody needs to adhere to necessarily, but there's a choice that's been given, and it's a source of pride in the industry. And so I get a lot of people who will call and they'll say, I just don't like seeing this in the industry. And I'm not going to give a specific example of anything, but that's why the code is there. It's so
right.
that you can have pride in what you have chosen to do as a career path. And so the addition of this might seem, now that it's going into more of a personal life, might seem like it's a little bit more of an imposition. Hopefully it wouldn't be. Or stepping over into personal boundaries. But there's also a pride that realtors have chosen to do this, I think.
They have, and if you post something, I mean, basically what this is a prohibition against using this hate speech as a weapon to attack protected classes. And where we saw it a lot this past summer, and we saw it a lot, and we knew it when we saw it without any procedure, is that the language and the postings were just violent and hateful and specifically directed at a protected class. And folks got fired over that. And, you know, I just also just say, think before you post.
Yes.
It doesn't, this
or
is,
repost.
Yeah,
Post or repost.
right. But it's not a limit on your beliefs. It's not a limit on your religious beliefs. It's not a limit on your freedom to think the way you want to think, but it is a limit on threatening another person or another class of persons simply because they are that other person or they're in a class of persons, mm-hmm. and using those words and those posts as a weapon. It is a limit on that. And honestly, you know, too bad. We need it, but we need it.
Right. And the code is a carefully drafted document.
It is. And people are highly trained. There's a series. This thing became effective November 13th at the National Association board meeting, November 13th, 2020. And it became effective immediately. Now there's still training going on for these folks that serve on the professional standards and the grievance committees. And there's a series of web meetings that have been going on, and they'll go through April. There's like one a month through April. So I don't see a whole lot of enforcement happening. There could be complaints filed for any activity that happened November 13th, on or after November 13th, but I don't think those pro standards process, I don't think those complaints will be processed until the training is complete. But the folks that sit on the pro standards committees are very, very serious. The standard of proof is strong, clear, and convincing that somebody violated Article 10 in this way. So, and you're going to have to convince 5 people sitting on a panel that this post was meant to be used as a weapon or to attack based on someone's membership in a protected class. So there's very strict definitions, there's very strict guidelines. Honestly, I have enough faith in the Realtor professional standards process that this will not be abused. And you know what? If you have to ask the question, examine what you're posting and what you're saying.
Mm-hmm. I agree.
Because it's just, it's here, and if you choose to be a Realtor, you're holding yourself to the standard. And then I will also, I think there was a little confusion with the activities of the Capitol, the U.S. Capitol, on January 6th. And folks were kind of putting those together. Like, oh, am I going to be prosecuted under 10-5? Well, without any facts that specifically fit within this provision, I would say no, it's 2 different things. You have an ethics provision that prohibits you from using harassing, hate, epithet, slurs as a weapon to attack a member of a protected class, and you have a perhaps criminal charge of trespassing if you broke through the barriers and crawled through the windows at the U.S. Capitol. Might you get fired if you're a real estate broker and you did that day? Hell yeah, you might get fired, because you've got a contract with your sponsoring broker that probably says, if you're being treated as an independent contractor, it probably says that you can be fired with or without cause, or either party, honestly, could terminate with or without cause. If there's a criminal conviction, that's going to be a cause. If there's not a criminal conviction, but you're on social media standing by the broken window, pretty good proof you were there. Pretty good proof that there's a crime there. Pretty good reason to say, hey, maybe better part ways here today. So that alone, it's a whole different matter. It's not the same. Now, if I stood at the top of the Capitol steps next to the broken window and then started using graffiti in slurs and epithets against members of a protected class, now I've got 2 problems. One might be under my Realtor Code of Ethics if I'm a Realtor member, and the other one might be that there's going to be a criminal action complaint against me. So they're 2 entirely different things. I wanted to address it. I think there is some confusion out there, so I want to dispel the notions, and I'm sorry for swearing, but I'm fairly serious about that. Grievance committees are obligated to assess the facts that are provided in the complaint as true, subject to the reply of the respondent, but you got to take them as true. But everything isn't going to rise to an actionable level. And I don't want to say that grievance committees just routinely say, let's just send it to a hearing and let the panel work it out. But this is one of those situations where you want to be very intently, every situation, you want to be very intently analyzing the facts to determine whether it is, if true, actionable before you send it forward. So, you know, somebody talking about their religious beliefs, dude, that's not actionable.
Yes.
It's not the same thing.
And I think the information on the National Association of Realtors webpage, it's comprehensive.
It's very, very comprehensive. So finally, during this session, I'd like to share a couple cases we're watching, none of which has really been resolved yet, but just want you to know that they're out there. We're monitoring and understand the concepts that are presented by these particular cases. One big one is the Nar Doj, which is a case that is proceeding, but in the context of a court oversight of settlement negotiations. So what's happening is NAR and DOJ are working out a settlement to some MLS policies. There will be some revisions to the MLS policies that really don't change the tenor or the intent of the MLS policies at all. But just to give you an example of what's coming down the line, that there will be a requirement for the buyer broker, there will be a requirement for the listing broker to publish their offer of compensation. That's in the MLS anyway. There will be a requirement for buyer agents to provide to their clients that information, so the clients know what their buyer broker is going to get paid. Now, let me side note, that's outside a buyer brokerage agreement, which a buyer is free to have a brokerage agreement with their buyer broker that calls for them to pay something in the event that the buyer broker doesn't get paid from the listing side of the transaction. There will be a specific provision that that prohibits buyer brokers from advertising that their services are free. They're really not free, somebody's paying. It's coming out of the listing side, and we all know that in the industry, but I do think that there is a common misconception in the public, consuming public of real estate services, that they really don't understand fully. I've told broker friends of mine, you can hold a buyer's face in your hands and tell them how you get paid, and they still don't get it.
They don't understand.
They won't get it probably unless they sign a buyer brokerage agreement where they're obligated to pay something. And there is a provision, there will be a required provision for non-member access, or a non-participant to have access to a lockbox. However, that would be subject to seller's permission. It's their house, their rules, and also it could be subject to the non-participant signing off on the lockbox agreement and to follow all the provisions of the lockbox agreement. Folks have been asking if they should be amending their MLS rules and policies yet, and the answer to that is no. The NAR is saying stay tuned, language will be forthcoming, but DOJ has to sign off on the settlement agreement. It is my understanding that once the settlement agreement is fully approved, that the other cases that are out there against NAR and other brokerages should be moot. Those issues should be moot. So we'll watch that with interest. Another case I want to mention, just to keep your eye on, is one that was argued in front of the Supreme Court on December 9th, 2020. We are watching it closely. It is the title, the caption of the case is Collins versus however you say Steve Mnuchin's name, I think that's it. That is the case we're watching, Collins versus Mnuchin, and it's a case where investors in the GSEs, the Fannie Mae, the Freddie Mac, they lost money when the FHFA, Federal Housing Finance Authority, was created and took over the oversight of these two GSEs. And the shareholders are saying, we lost money, and they're trying to make the argument that this federal agency is indeed unconstitutional. And I think they're taking up some of the arguments that were made in, we've reported before on the SELA Law case, SELA Law versus CFPB. So the questions in these cases are the constitutionality of these federal agencies, and the argument is that there's some separation of powers problems between the executive and not the judicial, the legislative branches. Now, in the SELA Law case, what happened was the CFPB director, they did find that that structure was a violation of separation of powers, and so they said the director cannot be, the director must be able to be fired by the executive, whereas the prior situation was the director couldn't be fired without cause. Kind of the same questions here. The questions of the Collins case are these. Does FHFA structure violate the separation of powers? And then if it does, what's the proper remedy? And you know, when you're talking about the constitutionality of a federal agency, if that just blows up because the court says it's unconstitutional, what happens to all the prior cases and all the actions that took place? So we'll see what happens. Just know we're following that one. And also just on a very, very local level, some of you may know that Illinois Realtors and an Illinois Realtor member plaintiff filed suit against the Village of Sauk Village because the inspection, the pre-sale and pre-rental inspection process didn't have any guidelines, it didn't have any checklist process, there was no warrant procedure in the event that the homeowner or the tenant or the property manager didn't consent. So finally, the village would not capitulate to our arguments that this needed to happen, like under the Constitution and legally. So we filed a lawsuit, and each time we amended our complaint, the village would come up with a new proposed ordinance. So where we are in this case now is we have a warrant process, we have a new ordinance, and my best information is this past week there was a meeting of the Village Committee of the Whole, and they approved a final checklist and a final ordinance that we should be seeing sometime soon, which hopefully will lead to the settlement and the disposition of that local case. I want to shout out to our Governmental Affairs Director, Tom Joseph, who was instrumental in advocating towards this solution, and based on a relationship with an administrator within the village, a prior professional relationship, they were able to get reasonable and get the thing done. So shout out to Tom. With that, our time is more than up. So I want to thank Anneliese for giving us really, really good information. I want to thank our crew, and I want to thank y'all for tuning in, whether you're tuning in live or later. And if you have questions following this session, we will put up a slide that gives you information for an email to send a question after the session, as well as the web address for the Illinois Realtors legal information. Thanks again.
Thank you.
Take care.